A California judge lets strip clubs and restaurants reopen during the stay-at-home order. Legal analyst Wendy Patrick joins us live this morning. Good morning to you, Wendy.
Good morning, Chris. How are you today?
I'm really well. Yeah, I'm so glad to see you. But let's break this down real quick, okay? Because we read the headline, that's one thing, and what this judge is pretty much saying is that there's no evidence that's tying the spread of COVID-19, right, to restaurants being open, to strip clubs being open. Is that correct?
That's part of the rationale, Chris, and that's important because talking about strip clubs creates a sensational headline for a straightforward ruling. These two adult clubs are businesses that serve food. And in that sense, that was really what was being examined in this particular case. Now, it's also true, Chris, in terms of how other jurisdictions would look at a case like this, that it just happened to include other issues like the First Amendment issue, freedom of expression, the fact that takeout and delivery options don't quite capture the reason someone might patronize an adult entertainment club. So there were other factors that other courts will look at because we don't have the luxury of pandemic precedent. It's been 100 years since we've had a pandemic. So it's not like we can say, well, gee, how did we deal with that question the last time it came up? So these are some of the ancillary issues in a case that really has the gist of the ruling being fairly straightforward, Chris. And as you mentioned, does apply to businesses that serve food, i.e. restaurants.
Okay, so for the meantime, that means restaurants or places that are serving food, is that correct? They can technically reopen.
Well, that appears to be the way you could interpret the ruling, and in fact, the way many are interpreting the ruling. And that's one of the things about court rulings that is so important. Words matter, and judges know this, and they take great pains to phrase what they want to say in a fashion that'll make sure that their enforcement is consistent with the way they express themselves and what they want the ruling to stand for. So here, both of the adult clubs at issue happen to have food licenses. Not only that, they also presented a great deal of evidence that the judge actually cited to in the ruling that they had to, they had basically one, they call them artists in the ruling, but dancers, one on stage at a time. They're masked. They're 15 feet away from patrons. Here's the other side of that coin, though, Chris. I got to say this as a trial lawyer. There's nothing that says patrons have to stay 15 feet away from each other. So that's part of the rationale of the governor's closure to begin with is bars, it's especially someplace where you are going to be there for a long period of time, breathing the same air, low circulation. That's someplace where you might have more COVID. But on the other hand, the judge pointed out that they couldn't tie any cases to these two establishments. And in fact, in general, it's hard to tie COVID cases to restaurants generally, probably because they take such pains to make themselves COVID protocol safe. So
Right.
without that nexus, Chris, it's hard to justify, at least so says the judge in this case, it's hard to justify having them remain closed, at least for now.
So does that mean, so for restaurants, speaking of restaurants, does that mean indoor and outdoor dining, or is it just, outdoor dining?
Well, see, you're asking me to interpret a judge's ruling, and I know that that's what other judges are going to be asking for as well, and that's what restaurants are asking for. It would be nice to have a magic answer to be able to say, yes, that's exactly the way this is going to be interpreted. But I hate to say that litigation leads to legislation because it's not always so easy to take one order and then sort of guess, even if it's an educated guess, as we're doing in this case, all the different types of businesses to which it might apply. Restaurants seem to be a safe bet, but again, it's only a bet, and time will tell. And also remember that this will probably be appealed, and within that appeal, we may gain greater clarity as to exactly what will and won't be covered by an order like this. And Chris, I hope this all becomes moot in a couple of months anyway, because I hope we're all vaccinated and everything's back open.
All right.
We have enough ICU beds to we're not arguing about this, and it's just
Right.
sort of an academic exercise. But for now, given this just happened yesterday, that appears to be one way that you could reasonably interpret the ruling.
Okay, Wendy, before I let you go, so that's what you're saying. The next step from the state or the county perhaps would be that they're just seeking clarification and an appeal would be coming.
Well, they're appealing the ruling, the order. They're
Okay.
appealing they basically want the governor's order to go into effect and remain in effect. So San Diego County is the second largest county in the state, and the governor in the state believes that those businesses should remain shut down. So they're actually going to be appealing this particular ruling. But in doing so, Chris, we're all going to learn a little bit more about it. And, some restaurants are afraid to open because they're asking the same great questions that you are. Well, I'm not a strip club. I'm just a restaurant. Does that ruling mean I can open too? I would advise people to read the ruling. It's online, and it does talk about businesses that serve food.
Okay. Oh my goodness. So many businesses can really fall under that umbrella. But Wendy, for now, we do appreciate your time. Thank you so much for joining us.
Thank you, Chris.